advocates with government and other industry partners on your behalf. We publish the Scrivener magazine, and we promote notaries throughout British Columbia and provide other member-centered services. We do not regulate the profession. We have nothing to do with your E&OE insurance or the captive insurance company, and we certainly have nothing to do with ProSuite. They remain wholly owned subsidiaries of the society. And the only reason I bring it up is because I know that we get a number of calls that we field often and inquiries about different things that are offered by the different parties. So I just wanted to make sure that we were clear. Furthermore, I'd like to extend our thanks to John Mayer and his good staff at the Society for all they do in regulating our profession. And my thanks to David Watts, President of the SNPBC, and their board of directors for always maintaining open dialogue between our two boards. As we begin this conference, let's be sure to soak up all the knowledge that our speakers will be giving us this weekend. And even more importantly, let's soak up each other. It's been too long since we've all been together. Let's meet new people. Let's form new friendships and reacquaint ourselves with old ones. Enjoy the conference. Thank you. Oh, sorry, I think Trista is next. There I am. Don't have my schedule with me.
Morning, notaries. I had to be careful walking up here because my pair of shoes yesterday busted a heel off. So my nerves are a little shot, but it's great to see so many of you in person, and I'm glad we could offer a virtual component as well. Can you hear me okay? Okay, perfect. I'm sure most of you know me from Zoom. I'm sorry I don't know all your faces, but I look forward to getting to know you this weekend. I'm Trista Zamani, the Continuing Education Manager for the BC Notaries Association. We have some great content over the next couple of days, and I'd like to take this opportunity to thank our Continuing Education Liaison Committee. This team has provided some wonderful feedback on hot topics, ideas, and presenter suggestions. So thank you to our committee members, Zoe Stevens, Hilda Dupre, Christy Martin, Maury Bailey, and Ron Usher. Thank you. I wouldn't be able to do this without your help, so thank you very much. A few housekeeping notes that I will just go over once. The Society of Notaries requires a verification code to confirm you've attended each session. So if you've downloaded the Event Mobi app, there's a process to put it in. I'm happy to help. You can also check with Olivia and Nicola. I am over there at the AV, but I am facilitating some virtual sessions from our exhibitors that are separate. So if you see me with a headset on, please go see the team at the reg desk and they can walk you through that process. This is how we track the attendance. For our virtual attendees, we've got you on Zoom, so no need to download the app. Just got to make sure I cover everything here. The continuing education credits will be reported to the Society within a couple weeks. Moving on to our first session of the day, we have Ray Riley and Patrick Tobin presenting on provincial land and water license issues from the Ministry of Forests. So Ray Riley started his career in the forest industry after completing his Forest Resources Management diploma at BCIT. After working in the forest industry in various parts of the province for nearly 20 years, it was time to follow his developing interest in water management, and he moved to the Okanagan to complete the Water Engineering Technology program at Okanagan College. Ray has been part of the Penticton Water Allocation Team since 2012 and is currently designated as an assistant water manager under the Water Sustainability Act. Ray is a married father of 3 living in West Kelowna, who has recently found himself struggling to keep up with the teenage kids on the ski hill. And then Patrick Tobin, who will present first, is the Senior Authorizations Officer for the Okanagan Shuswap Resource District with the Ministry of Forests. Patrick and his team of professionals and specialists are responsible for reviewing and authorizing tenures for the private moorage structures in the Okanagan Lake system. In addition, Patrick and his team review and approve applications for a number of upland developments, including gravel pits on provincial land, roadways across provincial land to isolated private land parcels and small utilities over provincial land. So I will pass it over to you. Thank you for being here on a Saturday morning. Enjoy.
How is this? Can you hear me? Am I coming through? Okay. Good morning, and I can't believe how bright-eyed you guys all look. I'm not sure I would be as wide awake as you are on a Saturday morning. Crystal gave us a wonderful acknowledgement and welcome to the land of the Syilx people. I wish she was here to hear my apology for how I'm going to present this morning. I'm hopeful that what I present will be informative, but not dry, but you'll be the judge of that. The thing that I'm going to suggest, though, as I speak and as Ray follows up and we speak, we're coming to our knowledge and our information from a colonial perspective. We are working very closely with the Indigenous communities in the Okanagan to map a way forward for more collaborative management of resources, but we're a long ways away from that. Reconciliation is going to take generations, I am sure, but we are working towards that. But I'm going to refer to many things that are legislative, prescriptive, and come from the context of the Crown. So just keep that in mind. Going to see if I can get this to work. Yay. Okay, cool. So I'm going to talk to you a little bit about private mortgage is going to be my focus. As Trista said, we also do a few things on Crown land out of our office here in the Okanagan that are not related to private mortgage. Specifically, we license gravel pits on provincial land. There's oftentimes parcels that people have bought where they need access to their property via a roadway or a driveway. We license those, and we also license small utilities. But the bulk of the work that we do in the Okanagan system, from midway up Merrill Lake down to the border, is private mortgage. And so in order to discuss private mortgage, and so by private mortgage, I mean docs for those who wonder what that is all about. In order to occupy Crown land and to utilize provincial land, you need permission from the province. And in order to construct in and around water, there's some regulatory framework that you have to abide by as well. So I'm going to sort of walk you, and I know this is the dry part of the conversation, but I'm going to walk you a little bit through the underpinnings of authorization that give people the ability to utilize provincial land for purposes such as private mortgage. And there's two key components to being able to build a dock or construct a dock or have a dock on the lake systems in the Okanagan. There's a legislative framework, and the legislative framework has two key components to it. There's the Land Act, which I am immersed in every day, and there's the Water Sustainability Act, which Ray and I share. Ray shares it from a different perspective than myself, but the Water Sustainability Act guides our business on private mortgage as well. The Land Act specifies under Section 60 that you cannot occupy, use, construct on provincial land without permission from the province. That's it. Doesn't give you any guidance, doesn't give you any direction on how one goes about authorizing or using or constructing. It just says you can't unless you get permission or authorization from the province. So within the scope of our ministry, we have 26 policy or business lines that attempt to put some framework and rules around things like wind power farms, things like commercial recreation, things like large transmission lines, any number of different uses on provincial land. There is a program set up. The program I'll be dealing with here today mostly is the private mortgage program. Interesting note, until a few years ago, if you were to hike on provincial land, just to go hiking and camping, you were technically breaking law. That's how basic this particular piece of legislation is. They came out with a permissions policy that now allows people to access Crown land, to hike on Crown land, to go bird watching, to go fishing, any of those number of things. But prior to, I think it was 2016, when that permissions policy came in, it was a contravention to actually be on provincial land. That's how basic this piece of legislation actually is. So this is what we're going to be talking about today. This is a basic private mortgage structure. That big sort of thing with the blue on it, that I believe that is a boat vessel tied to a buoy, but that's a basic structure. Now, interestingly, that is a basic structure for some parts of the and in the Okanagan, a basic structure, not a problem at all. However, in some jurisdictions within the Okanagan, for example, that would be a problem. So not only does the province have rules and specifications for how we authorize, but local governments also have their own rules and bylaws and specifications. The Water Sustainability Act, if you think of the Land Act as your lease or your license to occupy into the future, the Water Sustainability Act is the piece of legislation that gives you the right to build and construct. So it's your building permit legislation. So when a client comes in and they want to build a new dock, or they want to repair a dock, or they want to do anything on that structure on the foreshore, because it works in and around a stream, they need to make application, and depending on the significance of the works involved, they may need to hire a biologist to be involved because of sensitivities, zone, fish zoning, and that type of thing. So works in and around a stream is your building permit. Once the structure is built into the future, that is the permission to occupy under the Land Act. So those are the two regulatory pieces of the puzzle. There's a typical dock being constructed near Vernon. Most of our docks in the Okanagan, and I'm speaking primarily from an Okanagan context here, are pile supported docks. So a barge comes in with either steel piles or wood piles, pounds them in, and that's the foundation for a structure that is built in the Okanagan lake systems. So the second underpinning of all this is common law, and I'm probably going to get this a little bit wrong. So for those of you who understand what common law is, bear with me. In my peanut brain, common law works like this. Common law is not set in a regulation. So you won't be able to go to a statute or a regulation and find this written out. It comes to us, I believe, my understanding is it comes to us through history from England, from Great Britain, to North America, to Canada specifically as a Commonwealth country, where there has been an establishment of privileges that are granted people. And because of those privileges, people are entitled to be able to do certain things. So three of them that are in common law that we deal with all the time is individuals with waterfront property have right to access deep water all along the front of their property. So that would allow them, theoretically, to bring a boat into and out of their property. This is key because what it does is it curtails the province from permitting some use or activity in front of that person's property that would prevent them from being able to access their property. So putting in a fish farm in front of someone's property that precluded them access to their property could be problematic. Approving a marina in front of someone's private property that precluded them from getting access to their property would be problematic. What this also does is it gives us the sort of leverage to be able to use private moorage structures as a way of expression for these people to be able to use their property for moorage. It's not a ultimate or right. It can be denied, and there are zones in Okanagan Lake where if you never had a dock before because of sensitivities to kokanee spawning, you wouldn't be allowed to have a dock today. So it's not an ultimate right, but there is definitely a strength of argument that you can say in most cases people can express their right of access to deep water by getting a dock. A couple of other ones, we might go into them towards the end. Right of accretion, that's you get to add property to your property, upland property, if there's a slow deposition of material there over time. And as we saw in 2017, which was a horrific year in the Okanagan with the flooding and the damage, you have the right to protect your property from erosion. You just have to make sure your erosion protection measures are all on your land, not on provincial land. So private moorage in the Okanagan has a wonderful history back to the early 90s. and I'll skim through this pretty quickly. In the early 90s, there was a push for government to engage in an inventory and licensing process because the lake was becoming largely overrun with structures, in the opinion of many. And they wanted the local governments, Indigenous communities, other people wanted to see some level of regulation, more intensive regulation of these structures. So the province went out and inventoried every dock on Okanagan Lake and captured, somewhere in the order of 1,000+ structures, went out with a mail out campaign and licensed every single one of them. And back in the day, the licenses were for 10-year terms. So in the year 2002, 2003, all those licenses came due. And the ministry at the time had changed, as we do from time to time, different mandate, different priorities. They had all these licenses come due. What did we do? We rubber stamped them all. So without a lot of inspection or assessment of those structures, relicensed them for another 10 years. In 2011, the workload around managing private moorage, which would previously have been done out of Kamloops, our Kamloops office, moved to Vernon and our office. And the approach we have been taking in the last 11 years, 12 years is we're not going to rubber stamp anything anymore. We're going to go out and take a look and make sure what is there meets the mandate of the program in terms of specifications. So we have this sort of duality of non-conforming structures, which were historically authorized that wouldn't meet today's standards. And then we're moving them slowly into conformance with current licensing and dimensions and whatnot. So it's a very slow kind of process of getting people in conformance with current standards. This is one of the old forms of licenses. It's called a license of occupation. We no longer use these, but you may see them if you're working with clients on a realty transaction. They may come up with a license of occupation document and that it will have likely have been an expired license. There's going to be a process that we're going to go through with your clients to get their licenses renewed to the current license standards. And while we go through that process, we're also going to be taking a look at their dock to make sure that it matches what would have been allowed back in the day when it was built, and nothing's been added to it that we wouldn't allow. And are these, Trista, are these going to be, this information going to be shared with folks? Because there's some good links in here that might help people if they have an interest in being able to go and look for some of this information. But if you Google general permission docs in BC, you will get directed to this site. And it is the sort of the policy site where all of our rules around private moorage is housed. So you can go and have a look and see what are the specifications for a new dock and what are the terms of licensing that we use. This is the preamble to the general permission criteria. So there are two types of authorizations we provide. A general permission is a dock is deemed to be approved if it meets the specifications contained within the general permission. So the minister in 2017 set out the criteria. If your dock is this long, no wider than this, and it's set back from the property lines on either side by these distances, then your dock is automatically approved. It will carry forward to the next owner of that property, to the next owner of that property, and to the next owner of that property. There's no formal licensing that goes along with a general permission. So we spend a fair amount of time assessing old docks that come up for renewal or old docks that people want to work on to make sure they follow this criteria. We don't have, unfortunately, the ability to deviate from what the minister has prescribed here. If it meets these criteria, we're good. We can close the license file and we can just advise the persons that their dock is a general permission. If it doesn't meet the general permission criteria, then we have to enter into the more formal specific permission. And this is just the header of a specific permission document. It's 10 to 12 pages of boilerplate language with all kind of if and ors and signed by the property owner and signed by us. If a dock has a specific permission, it must remain as a specific permission dock. When a new person buys the upland property, then that license has to be assigned to the new owners. The previous owners have to relinquish their rights to it and the new owners sign on. So you may see if you're working with waterfront property in the province where there's specific permissions, this process of an assignment needs to be followed through with. So this is an example of a general permission dock. The June 1st of our 2017 general permission criteria were revamped, or not entirely, but tweaked in June of this last year. And this is a classic example of a general permission dock. No assignment is required for this, no formal license. And this structure meets general permission criteria because the length of the dock is less than 42 meters. It's set back 5 meters on either side from the neighboring properties. And the reason we have a 5-meter setback is not right away, because we have a lot of these docks from 30 years ago we're still dealing with. But over time, we will end up with a 10-meter spacing minimum between structures. And that helps support Transport Canada specifications and guidelines for safe boating. So 5-meter setbacks, the walkways out are 1.5 meters wide, and the platforms are no wider than 3 meters. So no specification on platform area. And this is a little bit of a bone of contention among some. Their platform area can be significant. And we've seen docks that qualify for general permission with upwards of 200 square meters of platform. So something that perhaps in time will be addressed. This is what we call a old or a non-conforming general permission dock. So the walkway widths are greater than 1.5 meters. This dock was probably built in the mid-90s, but it met the standards of the day when it was built. So this is what we call a non-conforming general permission structure. So now we're getting into those situations where a specific permission is required. Shared docks, our permission, our general permission policy, it's debatable whether or not it contemplates a shared dock, but we found that with shared docks, a formal license agreement is preferred because you end up can have challenges sometimes between neighbors on structures. And so it's good to have something in writing and that sort of lays out who owns what and what is the purpose of that structure. So shared structures are always are a specific permission formal license. And so when one property sells on a shared structure, there's an assignment of their rights to that particular half of the dock. All right. Not getting my next slide here. Here we go. Thank you. So you'll see here a roof structure, and normally a roof structure would be a big red flag. We do not permit roof structures on private moorage in the Okanagan or around the province. Marine applications might be a little bit different, but in freshwater, roof structures are not allowed. So remember I said in the early 90s, they went out and they inventoried everything that was there. Then the plan at the time was let's capture it all. Let's grab whatever is there. We'll license it as is, where it is. And in time, we will move that structure towards compliance with current standards. Many roof structures and other types of structures were captured in that net. And so we consider those to be existing non-conforming if they were identified back in the early 90s as being there. What we do say is no maintenance allowed. So once that structure falls into disrepair, it's time to remove that structure. So in this instance, because our general permission criteria do not allow roof structures, we have to go forward with a formal license. We do not have the ability to deviate from the minister's specifications. So in this instance, we would have to proceed with a formal license. Once that roof structure is gone and removed, the structure would likely qualify for a general permission. So when you're working with clients who have waterfront properties and they have these kind of situations evolving, one of the things I would recommend or encourage you to do is pick up the phone and call the local office and engage the lands officers in a conversation around what is going on here. So this is what, and I don't know if anyone here heard the term paper subdivision before? The concept you guys have, anyone's dealt with? So a paper subdivision is, and this one happens to be on Cow Lake, a paper subdivision is a one lot that is subdivided internally. So it doesn't actually have registered, pitted or deeded titles within the lot. It's a paper subdivision. And the rights of ownership, if you want to call them that, are by certificates issued by the corporation who owns that lot and says, Barbara and James, you're entitled to lot A. Here's your title. Here's your certificate for that. So it's an internal structure within the lot where the corporation issues occupation permits to the members or the shareholders of those lots. Because this is one lot legally, and we're only allowed to issue one license per lot, we have to enter into formal specific permissions for every waterfront property in one of these subdivisions. So paper subdivisions end up becoming de facto specific permission zones because our general permission criteria says one lot, one dog. Well, we got one lot here, but we got 25 properties all on paper with 25 distinct owners. We authorize them private moorage for their properties, but it's it's outside of the scope of general permission. Arc sites are another requirement. Any dock that is associated on an archaeological site is not does not qualify for general permission. So we do extensive reviews of all applications that come in, and if they are associated with an archaeological site, automatically requires a specific permission. I'm going to switch gears a bit here and talk a little bit about the component of the Water Sustainability Act that influences the way we do business under the land authorizations. And the big thing in the Okanagan is kokanee spawning and mussel habitat. So the kokanee are, as I understand it, a landlocked salmon. They are essentially a sockeye that has never gone out to the sea. And if you've ever been up to Adams Lake or in any of the areas where you see strong sockeye runs, you'll oftentimes see these little fish that look just like a sockeye, but they're not. They're typically a kokanee. So they're lake-bound kokanee. And the Okanagan Lake has pretty good kokanee stocks. They rise and they fall with a number of different parameters, but there's a big push to try where we can protect the spawning habitat for these fish. If you get a chance and take a look at, if you don't get access to this site here through sharing of the presentation, Google the Okanagan Large Lake Foreshore Protocol. It's a mouthful, but Okanagan Large Lake Foreshore Protocol. If you're interested about any of these critical species in the Okanagan and some great information on private moorage, best management practices, that's a great site to go have a look at. So this is what we're looking at when we talk about kokanee, little red fish. This is taken out in October of 2021. I was out doing a dock inspection and I saw my first kokanee spawners. Pretty exciting day, actually. So this zone, you'll see here this black line. This is one of our mapping tools. This black line represents black zone kokanee. That's our highest value kokanee spawning habitat in the Okanagan Lake systems. If you look here, There we go. That black line on the previous slide is based on survey information going back to the 1970s. So every year or every second year, a boat of 2 or 3 folks will drive, literally drive, is that the right word? Drive the foreshore of the lake and count kokanee during the spawning season. And each one of these little red squiggles represents a distinct count year and a number of kokanee. So in this site, you see, what's the number there? 620 kokanee were counted. And let's be honest, they're not going 1, 2, 3. They're kind of looking, okay, that looks like 100. That looks like 50. As they zoom by, I've seen these guys go by and you can almost water ski behind them, right? They're like, and I'm like, how are you counting? But they're clumping them, they're aggregating them. They've been doing this for years. So in that strip in 2002, there was 620. So that's the basis for why we know that these zones are critical for kokanee. Interesting. I'm gonna walk over here. There's a property here. You can probably see it with this little dock. And then there's a property here. That was one lot at a few years ago. And the owners of the lot with the little old dock on it decided they would subdivide and sell off a portion. Property values in the Okanagan insane, as you know. It's a great way to generate some retirement revenue. So they hived it off. What they didn't consider was the fact that that lot they hived off never had a dock on it previously. And it's a property in a black zone. And if you never had a dock in a black zone before, you're not eligible for a dock now. So they hived off that parcel thinking that they were going to get a good value for that lot, and they took a substantial hit in real estate values because that lot is no longer eligible for a dock. So shorten the story a lot, they ended up giving up the dock on the property they own in favor of allowing the new lot to have a dock, and are going to forego having a dock on their own property now. So the new dock, the property they're able to sell with a dock on it because they gave up one and replaced it with a new one. No net new docks built. They were able to salvage what could have been a difficult situation. They also could have built a shared dock on that property between the two, but they opted not to do that. So in this slide, what I'm attempting to show is we're going from black zone, which are our most critical, to our red zones, which are still critical, same sort of criteria, but they're not as restrictive as black zones, into our yellow zones. So you'll often see this transition from red to black to yellow, or yellow to red, or just yellow standalone or red standalone. And all of these zonings are based on kokanee counts going back. The other criteria that we watch out for, and this all comes to us through the applications under the Water Sustainability Act, like I say, for new structures, is a rare and endangered species called Rocky Mountain ridge mussels. No impacts on the structure per se, but it just means you're going to have to get a qualified environmental professional, a biologist involved, to do snorkel surveys to try to find out where the mussels are. And if your dock's going to be built where mussels are, you're going to have to pick up the mussels, tag them, and relocate them to a new spot so they don't get squished. So if you're working with a client, or God help you, you have a structure that looks like this in front of your own recreational property, I would say this is a big pay attention to. Yeah, there's a long story. I could talk for hours on this particular property, but the long story short, that structure is no longer there anymore. Some people, and innocently so, I think for the most part, have a perception that their upland ownership extends out into the lake for their use and enjoyment. But as I mentioned in the beginning, anything below the high water mark of your property is provincial land and requires permission from the province, and nothing like this would be typically allowed. And in time, we managed to get this structure removed, and the clients have a brand new dock that they're hopefully happy with, and we're much happier with. This was one of, back in the day before I filled this role, I was in compliance and enforcement, and this was one of the first docks we actually went to seizure on. We trespassed this structure because of this roof, dance hall we called it, and ended up having to send a barge out with crews to actually dismantle the dock and remove it from the lake, all at the owner's expense. So we already looked at it. I must put this one out of place. My apologies. And foreshore decks, we see a fair number of those structures as well. People, especially in steeper properties, people want to extend their recreational opportunities on the foreshore, so they will build out into the foreshore, over the foreshore. And that's not something we allow typically. So structures like that will be required to be removed. Interestingly, when a large number of files that we work on yearly come to us through realtor transactions. And with the hot market that we've had now for the last couple of years, where properties are selling upwards of $12 million in the Okanagan, we oftentimes have realtors call us asking, what's the status of the foreshore here? What are there any red flags we need to pay attention to? And we'll point out things like this to the realtors, say, this is a problem. This is going to be a liability for the new owner if the transaction goes through. So the seller, motivated to complete the sale, will oftentimes affect removal. If they don't, then the liability carries forward to the new owners, and we see oftentimes in realty transactions holdbacks. So there'll be $150,000 holdback pending the cleanup of the works, and then the holdbacks are released. So I'm going to talk a little bit about a couple of the other things with respect to foreshore rights, because they do have a direct impact on property, and they do have a direct impact on what a person has rights to on the foreshore. So if you look at a legal plan for a property and it has on it a descriptor present natural boundary or natural boundary or high water mark on the older plans, it's indicative of a key piece that property is bounded by water, and water is an ambulatory creature in that it will move up and it will move down and it may erode and it may add, but it's forever changing depending on the influences of the system you're in. In the Okanagan, we have it's a regulatory system in that there's a dam down in Penticton that can be opened or closed to moderate the amount of water that comes in. And anyone in the Okanagan, from the Okanagan here, probably seen the lake, never seen the lake this low before? Yeah, there's reasons the lake's low right now, and without going into Sean Reimer, one of our coworkers' business, he manages the regulatory system. There was snow in the hills in Vernon yesterday in April. So there is some concern about letting go of all that snow with rain and how fast the lake will fill up. So it's a constant juggling act of water up, water down, how much to let go, how much to hold back. Water moves. And so with the movement of water, the foreshore, the ownership of the property can change. Accretion, as I've mentioned, is a slow addition to your property over time. And we see this happen around some of the major creeks in the Okanagan, where sediment is dumped into the lake and it slowly moves along and it settles down. And then over time, upland vegetation grows. Well, that's typically signs of accretion. that property that's added, you own that land. There's also erosion, as we talked about, where you get events gradual over time, but sometimes can be somewhat catastrophic. If it's catastrophic, it's a different category, but over time you can see properties lose land and that land reverts back to the province. So a natural boundary, so is in a layman's terms, it's successive years of high water that slowly establishes a change in soils that is allows the establishment of upland vegetation. What we tell people is, think about your property that you've been on for this many years and where's the water line at high water any given year. You can oftentimes see it with little bits of rubble or bark or whatever along the shore. That's a pretty good indication of where you own up to. Anything below that's provincial land. Now there are the odd properties, and out here in front of Water Park, the city owns actually out into the lake. Those are super unusual. If it's overtopped by water, typically the ground underneath it is owned by the province, but there are some exceptions. So here's an example. You see the sort of gold yellow line going out into the lake. That is where the property was when it was surveyed back in the day. And I think the surveys here probably go back to the 50s, if I'm not mistaken. The red line that you see there is my rough approximation, just sort of looking at the imagery from the air, where I think the natural boundary for that property might be. The only persons who can actually determine that legally is a BC land surveyor. But you do this enough, you kind of look at it enough, you can get a feel for where you think it might be. That's my rough approximation. So if anyone knows anyone who owns these lots, don't take my word for it, but it is a good approximation of where the boundary is. That means that sliver or that hump of land that's out beyond the docks, that's now lost to those property owners. That is eroded, that is returned to the Crown. So that they no longer own out to there. And we've had in similar neighborhoods some pretty heated conversations with folks who think they own out to the end of their dock because that's where the survey shows it was 50 years ago. They've lost that property now. It has reverted back to the Crown because it's eroded. Likewise, you look north, you'll see the line dips in and there's a significant gap or a piece of property between the gold line and my estimation of the red line. There's a high possibility or a probability that that owner now owns out to the red line. Now, interesting, they own it once it's accreted. The trick or the catch-22 is they want to do something on that land. They need to prove to us that they own it. We wouldn't just let them build a Quonset hut there or a hut there or put a wall in there until they demonstrate it. But technically, they legally own it once it's accreted. It gets a little bit tricky when you're trying to use it for some purpose, though. So this is the blue line here is flood event 2017, where there was some significant high water, some of the highest water in 200 years. So we would not establish the boundary of these properties based on the blue line because that was a once in a 200-year event. So that blue line, while that may have been where the water reached in 2017, is not indicative of where the natural boundary for these properties are. This is a section of beach not far from here. And you can see the surveyors put out some stakes on the foreshore. We got some sort of detritus. This is earlier in the year on the beach that suggests the wind and waves took some of the material up to that point. But we have no idea where the boundary of this property is because these beach areas are so heavily modified through raking and landscaping and cleanup and vegetation removal that you cannot definitively say where the boundary is here because it's not been allowed to naturalize. So I was on this site with the owner of the property and the surveyor general trying to figure out where the boundary was, and it was a very lively conversation. The solution would be to put in a fenced-in area and let it just do its own thing for a few years. And if natural vegetation established itself anywhere in there, you'd get some indication of where the boundary was. But the surveyor general, no disrespect, threw up his hands and said, I can't make the call here. And the surveyor said, I can't make the call here. And I said, oh, I can tell you it's right over here. And they said, you're not qualified. So these foreshore properties, especially in urban areas where there's lots of activity on the beach, can make ownership really challenging. This is an example of an area in Vernon, Old Stamp Mill Road. So what has happened is back in the day, people did this. Sometimes they do it today. They don't like how much front yard they have. They want more. They'll put a wall out into the lake and they'll backfill it. And we call that an unauthorized fill. There has been, through the course of government history, different approaches to how to deal with these. In the early 2000s, the ministry at the time was much more in the business of let's make a buck off of our land. And so there was a lot more sale of land and activity. Many of these areas with unauthorized fills were sold off at the time. So, and that's not necessarily a bad thing. At least it legitimized the use that was ongoing in those areas anyways. The interesting thing is, once you survey the front of your property with we call it a tight chain survey. So now you have a legal plan that actually has a meets and bounds on the front of your property. You're no longer ambulatory. It's no longer an ambulatory property. So your property ends where that wall is. And if through the course of time, Mother Nature dumps a whole bunch of more material there and it grows up, you own where the wall is. That's where you own too. You no longer are bounded by an ambulatory property. So it can make determining ownership on water, especially on water systems that are somewhat active, very challenging. Here's a construction project in Kelowna. And so this speaks to protection from erosion. So you can protect your property from erosion, but all the works that go into those protections have to take place on your private upland. So the footings of the wall, and here's an example of some footings being prepared to be poured for potentially a wall going in, have to be constructed on your private land. And depending on how the wall is constructed, it can have a positive impact to the environment around it or a negative impact. And one of the things the province has been trying to push, walk away from, or not walk away from, but discourage, are these up and down concrete or cinder block walls on the shore, because they act like a rebound board. So the waves come thundering in, they bounce off these walls, they bounce out, and they actually gather the sand and the beach material and they push it out into the lake. So what ends up happening on many of these properties where you had a beach, now you've got a straight up and down wall that the water comes up to and goes up and down, but you don't have a beach anymore. So when you're thinking about going into protecting your property from erosion, think about what are ways that will work with the water as opposed to against the water. And this is an example of a very sad case. I think this home was built in the 1970s or earlier, if I'm not mistaken. The gold line here really and truly is the property line for this property. Anyone see a problem? So that's an alleged trespass area. And I say alleged because until it gets proven in court, everything that is in contravention is alleged, right? Or it's addressed through enforcement action. successfully. So this person, and I met him, gentleman at the counter, and he fully admitted, yeah, he pushed it out and he built it, and what are you going to do about it? And well, that's a good question. What are we going to do about it? Tearing down someone's home is not a viable option, really, for a historic home. Maybe if he built this last year, there would be grounds for the province to go in and say, remove it. But this thing's been here for 50 odd years or more. What ends up happening is the province will entertain applications to authorize or sell, typically it's sell, enough of the foreshore area there to protect the foundations of the home. So they might get 5 meters out from the front of that house sold to them. And then the rest of it's got to be removed and returned back to a natural state. So while the province isn't currently in a selling property mode these days, there are extenuating circumstances where a person can rectify an historic wrong and work with the province to bring it into some form of compliance. You may not get everything that you wanted, but you will get something that hopefully your home maintained and saved. So, and the rest of the slides are really just resources that you can go to. So if the slide deck's being shared, I would encourage you to take a look at some of these. The one that I think is kind of cool, and if you Google NROS, NROS, natural resource, geez, I can't even remember what the OS is for anymore. But if you Google, it's one of our portals for the for government website for some very interesting tools. One of which is access to mapping tools, and this is just the screens you will see on your way to the mapping tools. Discovery tool is brilliant. You can put it on your phone. It runs off Google Earth as a platform. It'll bring in all the layers of private ownership. It's not 100% accurate. Sometimes our cadastre, they call it, the lines that are overlaid on imagery doesn't quite match up, and you'll see it sometimes when you're looking at a property and the property line goes right through people's homes. Well, you know there's a shift there, right? But it's a pretty good tool, and if you are a fisher or hunter or like to explore, you can take this tool with you, and you're wondering whether or not you can start your hike here. You can look on Discovery Tool and you can see, oh, actually that's private property. I'll be walking through there. I'm going to drive up the road a little bit. So it's pretty good little tool. It's on my computer every day. Every day I'm using Discovery Tool to check, because one of the things we verify when we're doing our reviews of private mortgage applications is where these zones are. These zones can be uploaded into Discovery Tool or uploaded into Discovery Tool. So you can get a quick look to see what kind of kokanee zone you got, whether you got a mussel habitat zone in front of your property. And this is just, once again, how you start the Discovery Tool. One thing I will say, here's my phone number. Please feel free to call me. I don't mind. But if you have questions or you have a request for a review, and I would encourage you to do so, get a hold of us and we'll direct you to how to make an application in the Okanagan. I won't be able to take, unfortunately, calls from folks in Fort St. John or on the coast for sure. I won't know anything about the realities there, but if you're in the Okanagan, get a hold of us and we'll steer you in the direction, hopefully, that can get you answers for your clients. Yeah. Absolutely.
Okay, so if somebody, you'd mentioned if they've got property, they want to prevent erosion within their boundary of the property, they can build a lot to prevent further erosion. So once they do that, does that take it out if it's no longer an ambulatory property?
That's a great question. No, it doesn't, because it's still ambulatory. There still could be sediment deposited in front of the property. So So I see where you're going. The ones that we call straight line surveyed, they were trespass lots. So there was illegal fill with walls put in. Those were sold to the clients. So they now own those as part of their plan. Like they'll have an EPP or they'll have a KAP plan in this area. They are legally surveyed. So a surveyor goes out and runs the meets and bounds of that wall. Once that's done and registered on title, that fill area that was once illegal and is now owned by the property owner makes that property non-ambulatory. But if you're putting a wall in on your property, you still have an ambulatory boundary. You're just preventing that boundary from pushing upland into your property. It's not being legally surveyed any differently.
Okay, but historically, over a longer period of time, you're probably going to get the long run more erosion than you will accretion, would you not?
Depends on where you're at. That's a brilliant question, and I'll tell you why. Because if you walk the beach here in Kelowna, and you go along, you will run into a wall going out into the lake. And most people would look at that and say, this is a trespass wall. But if that person built that wall 50 years ago when the property was out there, they've maintained ownership of their property. They protected it from erosion and their neighbors didn't. So people have argued that the foreshore needs to be made more accessible. However, the people that have historically built structures out into, not out into the lake, but to the property lines years ago where it's eroded around them, they own that property still. Right? So I'm not sure if I answered your question or just went down a rabbit trail.
I was just trying to figure out whether in the long run, there'd be more erosion than there would be accretion.
It really depends on the system you're in and where you're located.
And where you're,
I should have just given you the simple answer.
Fair enough. Just one last question on, this goes back on the paper subdivisions.
Yeah.
So when you've got, let's say, and I'm guessing more often than not, a corporation that owns a large chunk and now has done that paper subdivision and has done maybe, sold shares off on those different papered lots. And they've probably got just like an internal usage agreement for those lots. And yet, then the province will then allow for docks all along on those papered lots. Is that correct?
I know you want a simple yes or no answer, but I feel compelled to give you a bit of a longer one.
Okay.
So yeah, I'm just trying to figure out how to say this. So I'll get myself into trouble. The province and especially in this program, and you right at the beginning, I said there's one statute, Section 60 of the Land Act says you must not use land without permission. All the rest of our business is guided by policy, and policy is not as strong as regulatory. When it's in the law is the law. When it's policy, it's strong indication that you have to do it this way. But there are influences and there are things that can change how you approach a certain situation. So our favorite two words in my business for every situation is it depends. It depends. And it really does. So we oftentimes carry on doing business because a decision was made 20 years ago to operate in this way, and we honor that way and we carry forward. So the whole issue around paper subdivisions is a bit of a mess that's been in place for 20 plus years. It came. Please do, absolutely, because we are all open to the vagaries of government decisions and mandates and whatnot. There's a strong linkage to the common law principle of right of access to deep water for a property that is titled, but it's a murkier, grayer area for a paper lot in a one lot corporate subdivision, whether or not that paper lot is entitled to that same privilege, right? So we have allowed lots within paper subdivisions this privilege. Looks like a fish, smells like a fish, but not always a fish. Yeah. Could that help? Okay, and I'm stealing Ray's time now, so. I think Trista was going to have us have a Q&A afterwards and I'm happy to answer more questions.
Do you want
And-
to do two quick questions from online?
Sure.
Okay. The acts, do they apply to tidal water?
So I heard a no, and I'm from the audience, and I'm way out of my wheelhouse. I don't do marine.
Okay, thank you.
Now, yeah, I don't do marine, and I shouldn't weigh in. I
Okay,
know that there are Land Act provisions that speak to under the specific permissions policy, marine environments, but there's more to it, and I would hate to mislead people. So if you have any questions about that, I would get a hold of your lands authorizations program in the area you're working and ask them some good questions about that.
thank you. And what's the time frame to renew the moorage license if it has expired?
What's the time frame to
Renew the moorage license if it has expired?
It depends. And it does. I mean, it can be a fairly straightforward process for renewals, but can also be lengthy depending on how complicated the site is and how messed up the site is. And it also depends on staffing and resources. And I mean, we have a backlog, and this sounds horrific, but we have a backlog of about 300 expired licenses. We are working our way through and have been for 10 years, and there's probably all be retired by the time they're all assessed. But we are getting through them, and we are not telling people you can't use your dock just because your license is expired. It just takes a while to work our way through. So,
Thanks, Patrick. That's everything from online, so we can pass it over to Ray.
okay, cool.
Is this on? You can hear me? Thank you. Good. All right. So good morning, everybody. Thank you for having me. Thank you for the invite. I will start just with a note. We did, as far as the provincial water program goes, we did a face-to-face back in March. And I'll just sort of reiterate what the introduction was this morning. And that's the first time we were able to get together as a whole program since pre-COVID. And it was really important, and it was a really great experience because in our program, we've had a lot of turnover in the last 3, 4, 5 years. So there's people that have been working together virtually. They've been working out of their basements, wherever. They've never met each other. So the ability to be face-to-face and actually have these conversations and get to know people is critical. It's really important. So I'm going to be talking about water licensing. We've been having discussions with Trista over the last little while, Patrick, myself. She's presented us with some topics for me to speak about. I work in the Penticton office with the Okanagan-Shuswap Natural Resource District. So we cover the area from the border up toward up into the Shuswap. We take in a little bit of the Similkameen, and then we go out towards sort of Big White. That's the area that I operate in. The principles and the acts and the regulations and everything that I'll be talking about are province-wide. So the principles remain the same province-wide. There's some nuances wherever you are about how the work actually gets done. So there we go. So in our First Nations introduction, she made a joke about a couple of hours of dry presentations. And I thought, well, we're talking water. How can it be dry? But in the work that we do every day, we are just like flooded with bad water puns. We're constantly inundated with these bad water puns. So yeah, I'll leave it at that. So I was just going to mention, go through a little bit of brief history of BC water law, and I'm talking about modern history, colonial water law, as Patrick mentioned. We'll bring up to the Water Sustainability Act that came in 2016. One of the things Trista asked about was registering wells and licensing and the difference between those two things. Talked about the transition period that we've just been through, discussion of fees and rentals. Mentioned G Wells, which is the groundwater and aquifer wells database, and some licensing database and tools that people can use to help find information if they're helping a client. And then just end up with some water notations and we'll see wherever else we go. So brief history, I'll try and make this quick. Actually, I'll mention there's a very large clock right here below this TV. And it's like something out of NORAD and it's a countdown clock and it is very intimidating. I feel like it's going to go to DEFCON 2 or something there and I'm going to be, I don't know. So briefly, the modern water laws in BC started with the 1859 Goldfields Act. It was in response to the gold rush that was happening and the increase in demand of people looking for water and then people fighting over the access to the water. There were various acts that came in post that and through the sort of BC joining Confederation and a number of those came in the intervening 50 years. Then the province got together and put those all together, consolidated them into the first Water Act that we had in 1909. That Water Act brought in the concept and it legalized the concept, the idea, the Western water law concept of first in time, first in right. So whoever was there using the water first, whoever had the license first has the first right to that water. It's a key piece of that act, and it stayed in that Water Act through the entire 100 years of that first act's existence. What it didn't do, that very first Water Act, did not consider groundwater regulation. So anybody using water out of a well, no regulation. So that Water Act went through a number of amendments through the 20th century. It brought in things as society changed and as priorities changed. It had various amendments until the province realized that it's the 21st century and we're operating with 20th century legislation. So the province underwent a process traveling around, getting input from stakeholders, getting input from First Nations, getting input from water users, citizens about what to do with the old Water Act. In the fall of 2015, they introduced the new Water Sustainability Act, and it came into effect on February 29th, 2016. Pretty big deal for a brand new act to come in sort of in the middle of somebody's career like this. And it was pretty interesting. It was pretty neat moment for us. They're working in the water field. The WSA repealed and replaced the old Water Act. There were a few sections of that old act that still remained, and they were renamed and repurposed as the Water User Communities Act. Real pared down, small piece of legislation specifically just to water user communities. But the WSA repealed and replaced that old Water Act. What it did do as well is it reenacted that fit for water rate system. So that's still the system we have in place, first in time, first in right. It also incorporated a number of measures from other acts that existed in the province, like the Fish Protection Act. So it brought in some of the clauses from the Fish Protection Act that allow the province to take action in times of scarcity or drought. I think through the experience of the late 80s, 90s, early 2000s, it made more sense to have those provisions from those other acts incorporated into the one act. It just made it easier and cleaner to use. So the WSA brought in a number of new measures. Like I say, the main one and the one that affects my day-to-day work the most is the regulation of groundwater. It's a big deal. We'd heard up until that point that BC was the last jurisdiction in North America to actually regulate groundwater. And that doesn't really feel like something we should be wearing as a badge of pride. Took far too long to bring that in. I'll just say that. The other pieces of the WSA, the important new pieces, were that gives us some different tools for management during scarcity. So like I mentioned, the Fish Protection Act, the clauses that are coming in from that. It gave us provisions for developing water sustainability plans. So if a local area has concerns about how the water is being used or concerns about the watersheds themselves, they can introduce something called a water sustainability plan. So they get the whole community together. It's kind of like a landscape use plan or an old forestry land and resource management plan. I don't know, any nodding heads? No. Not familiar with those ones? Okay, that's my forestry past, I guess. So yeah, the water sustainability plans are a big deal. There's a couple that are underway right now, but there's none that have been carried through to completion because they're a huge process to go through. Another thing is that came in with the WSA is the need for the assessment of environmental flow needs. So in the FIT-FIR system, the license with the oldest date on it has the highest priority. Now under the EFN, there's a thing called environmental flow needs. It's calculated for a stream or for a reach of a stream or for an area. Then that effectively moves up to the highest ranking position in that FIT-FIR scale. So if we are considering a water license application, we have to make sure there's the environmental flow need gets addressed first. Then we can see if there's water available to issue a new license. And then there's also provisions for introducing what they're calling shared decision-making, kind of goes with the water sustainability plans. That is something it's really emerging right now. There's some new initiatives coming out of another ministry, the Ministry of Water, Land and Resource Stewardship, with the watershed security strategy and the watershed security funds, and they'll be working on this shared decision-making. So it won't necessarily be myself, other bureaucrats, other civil servants working in an office making the decision. It'll be shared with local communities, Indigenous communities, wherever that is. So I mentioned groundwater regulation is a big part of the new Water Sustainability Act. Use of groundwater from a well for any purpose other than domestic use requires an authorization. When I would say authorization, I'm talking about a water license. So WSA Part 2, Section 6 says, subject to this section, a person must not divert water from a stream or an aquifer or use water diverted from a stream or an aquifer unless that person has authorization or that use is authorized under a regulation. So there are regulated uses where an authorization is not required. As an example, one of those is fighting fire. If you own a rural property or something, there's a forest fire going on, you don't need to call the province to get authorization to take water out of a stream to try and put the fire out. Go ahead and do it. The only rule is that when the fire's out, you have to stop diverting the water from the stream. So. When the WSA came in, the province was sort of in a situation where, because we had this 100 and some odd years of non-regulation of groundwater, so water out of wells, then all of a sudden it was regulated. We had people that were operating within the law because there was no regulations. Then all of a sudden, February 29th, 2016, there's a new law and those folks are all suddenly out of compliance. So the province had to come in with a transition period to bring those users that were using prior to the act into compliance and into the water licensing system. So they came up with this WSA Part 7, Section 140, talks about a person who on the date Section 6 comes into force is diverting or using, including storing water other than described in Section 6 from an aquifer for a water use purpose. They may continue to do so. And then A and B just say how they need to apply for a license. And they have up until a certain date to apply for that license. After that date, they're sort of out of luck. So the estimate originally was that there was about 20,000 users province-wide that transition piece would apply to. So huge task, huge numbers. So the province needed to come up with some incentives and some reason to convince folks to apply. So a couple of the things they did were surrounding the data first use piece, and this applies to FIT-FIR specifically. So if you are a transitioning groundwater user, you would apply for your license, and you could provide information to the province about when you first started using that water. So if your well went in 1980, you started using it in 1981, you can provide us with something that says we started using the water in 1981. Then when we're issuing a license, 1981 will be the priority date on that license. Normally, the application process is if you're a brand new user, you're submitting an application on April 22nd, 2023, if it comes in today, then the priority date, the date of use for that would be today's date. So you can see there's an incentive there to effectively backdate the use and recognize the use going back to when it first started. And then if you think about how, the fit for piece where you stack up all these licenses, and the idea is the oldest license has the first right to the water. If you're able to sort of slot your license in there into a 1981 license date instead of a 2023 date, there's obviously an advantage there. So that was one of the incentives. Water license applications, there's a fee for making an application, so the province waived the fee during that transition period. And then there was exemptions written into the regulations about what a transitioning groundwater license application would need to submit. So a new user would probably have to submit to us something about an EFN study. They may have to do a pump test. They may have to do different analysis that could be costly, quite time consuming. But a transitioning groundwater user would be exempt from those things. So another sort of incentive for folks to apply. So the original transition period was for 1 year, 2016 to 2017. As the date approached in 2017, the province realized we've hardly had anybody apply. So they extended it by 2 years to 2019. As that date approached, same answer, not really good uptake of the applications. So they extended it to March 1st, 2022. And there was a huge rush leading up to that because I think the province this time had put the message out that said, okay, we've extended it twice already. This is it, no more. This is the date. So there was quite a large rush of applications leading up to March 2022. So this transitional period now is over. Those incentives are gone. Anybody who's using water, either from a well or surface water, whatever it is, if they're going to apply for a license, they have to apply as a new user as of March 1st, 2022. So that's the groundwater licensing. So remember, that is for a purpose other than domestic. So irrigation, somebody's running a greenhouse, maybe somebody's irrigating a golf course out of their well. For domestic use, there is a well registration process. So this isn't a license, it's just a registration. So just to try and make this clear, the domestic purpose in the Water Sustainability Act is defined as water used for the occupants of a private residence for household uses. Household uses including drinking water, food preparation, sanitation, fire prevention, water for animals kept for household use or as pets. And we get a lot of calls about that. Or irrigation of a garden not exceeding 1,000 square meters. So 1,000 square meters is about a quarter acre. So if somebody's got a lot with a house and a nice vegetable garden in the back, maybe some flowers, whatever it is, that's still considered a domestic use. That's not, you're not getting into any irrigation and you don't need a license for that. The questions we got a lot were during that period were for the animals kept for household use or as pets. We were getting lots of calls. Look, I have half a dozen chickens in the backyard. Do I need a license for that? No. I have a horse that's on the property, for the kids. Do we need a license for that? No. So yeah, lots of questions like that. And lots of that sort of people bumping right up against that gray area, right? Where you would move from a domestic use into something that's maybe commercial. So that was a big piece of it. So the well registration, it creates a record of somebody's water use so that if the province is considering other applications in that area, we can consider your water use when we're making those other decisions. So if you have a well for your domestic use, if it's registered to the province, if someone comes in next door and wants to put in a large greenhouse operation or something, they're going to put in a well. They're going to be drawing a lot of water out of that well, potentially. That could affect your well and your access to your domestic use. So the province will be sending you something saying, hey, look, we have this application next door. We'd like to get your opinion. We'd like to get your input. Do you have any opinions on it? Do you approve? Do you not approve? That sort of thing. So if we don't know that you're using the well, if we don't know that use exists, then we can't consult with people on that use. So the registration process, I don't know how, yeah, it's probably small. Anyway, the guts of it are that it's a two-page document. Front page, name, owner, civic address, that sort of thing. Looks for the legal description of the property. It's asking for parcel ID, you'll know it. It asks for a small sketch of the property if you can do that. Pretty basic. We're not looking for something, AutoCAD or anything like that. There's an example on there in the bottom left-hand corner with just the property line. It shows a house, it shows a driveway, and then it has a little note on there saying, 100 feet from the corner is the well, kind of thing. So something else it's asking about on this well registration form is the well plate ID, and that's what I'm showing here on the right. So for a while now, anybody putting in a well has to be a qualified well driller. And when they put in the well, they're supposed to be putting on these well ID plates with a unique number for each well. So that one there, 48922, that's just a stock sort of photo that we have that we use for presentations like this kind of thing. So if there's a tag on the well, if there's an ID plate on the well, and if you're going to register the well, if you're helping somebody out do this, then putting that plate on the well registration form document is key, because it helps us figure it out. So what I did was I went to one of the tools the province designed to help with this process, and it's called the Groundwater Wells and Aquifers tool. So this is just a bit of a screenshot. It's just sort of the top half of the page. But you can see there's the province there, the top half of the province. There's a whole bunch of blue dots all over. Those are wells. And then there's on the left-hand edge there's a well search function. So I took that last well plate number, punched it in there just to see if it was actually, a legitimate number or not. And what came back was, that's changing, there it is. So what the database came back and showed me that this was a well up on the north end of Gabriel Island. So that well plate is actually in the database, it's there. So this is a pretty helpful tool for somebody who's going to be registering a well, or if you're buying or selling a property, you want to know if there's a well on that property, if it's registered. I've just captured sort of the top half of this just to give some of the details. It shows the address, it shows the lot number. Well, that's quite small down there. I'm having to squint for it, but it gives you a bunch of the information about the well, the location, the UTMs, that sort of thing, the GPS locations. If I was able to scroll down on this right now, it would show you more details about the well, the depth to water, the static level of the water in the well, the diameter of the well, how the well was constructed, that sort of thing. So the whole well record is attached to this. So it's quite a handy tool, whether you're buying or selling, or whether you're helping somebody do this. So, and this, the well registration form, front and back page, like I say, putting in as much as they can, and then it just gets faxed or emailed. I'm not sure, does anybody fax anymore? I know the fax number's on there. We have it on our office. It seems like something that just needs to go away. Email. So a couple notes, I've mentioned this a little bit already, but if you're buying or selling a property, if you're helping someone with that, it's key to either seek or share information about any wells located on the property. So if I was looking for a piece of land, I would be asking for copies of the well record if they have one, asking for any water quality tests that may have been done, if they know of any that are out there, asking if there's been any pump tests done, any flow tests, any capacity sort of testing of the well. If I was considering a well for an irrigation project or something, I'd want to know that, the well's going to produce 25, 30, 40 gallons a minute, whatever it is I need to take out, something like that. And then another piece is asking if there's other wells on the property that the owner's aware of that are not in use. So part of the suite of regulations that came in with the WSA, one of them is a groundwater protection regulation, and it says that any wells that are on the property that are not in use have to be decommissioned after a certain number of years. So that's a big deal, and that's potentially a big liability for someone who's owning a piece of property, and if they're aware or even unaware of those wells existing. So well registration, but also if you're helping someone, or if you're in the position of buying a piece of property and there may be a water license on it, Asking for a copy of that license, asking for a copy of the most recent invoice. Important things to get from somebody if you're considering a purchase. So the point of that being that if you're buying a property with a water license attached, the water license is attached to the property. So when you take over the property, the water license will come with it. But also any associated water fees and rentals, any overdue amounts will transfer to the new owner. So pretty important thing to have a conversation with about the owner if you're considering buying a property. When a property changes hands with a water license, there is a license name change process that has to occur, and that's through Front Counter BC. Again, it's an online application, but it's fairly straightforward. It's a largely just an administrative change, and once the property's changed hands, and once somebody has a new certificate of title for that property, they can go on and do the water license name change through that. One of the other tools developed in addition to that GWells tool was the water license search tool. So this has the database, the full database of all the water licenses in the province. There's a number of criteria that you can search by. I've just taken a quick screenshot of what that tool looks like. The easiest search tools are obviously the water license number itself, if you've got it. But chances are if somebody's got the license or the license number, then they've got a copy of the license, so you may not need to search it anyway. So license number, file number. Another easy search through this is by client. You can just punch in somebody's last name. If it's a fairly common last name, you may have to sift through a number of licenses in your results to find the one that you're looking for. But if there's some, if you're considering buying a piece of property from say Patrick Tobin, and he's suggesting there's a water license for that property, and you go into the database and his name doesn't come up, then I would be asking maybe some other questions. One of the things Trista mentioned was what's actually in a water license. What does a water license look like? So right-hand side is a water license, and then a few of the pieces there. The license document itself is a number of clauses that describe the terms and conditions of the license. Things like the purpose for which the water is to be diverted. This one is an industrial purpose for a fish hatchery. The source of the water to be diverted. I think it's the very first clause on this shows it as the Sayward Unconsolidated Aquifer. So that's the aquifer under Sayward on the North Island there. Quantity of the water to be diverted. I think this is 2,880 cubic meters per year. The location of which the water is to be used. So that's the appurtenant land, the land that the license is attached to. The appurtenancy, the description in this one is interesting, and I'm sorry, I can't read it because it's fairly small, but it's a little more interesting description than we would normally have on a license, because this is a piece of leased land, and then there's a very specific description of where the water is to be used. So other things like the location of the water, where it's going to be used, the season of use. So whether it's an irrigation license, it's going to be used for just maybe a 6-month period, or something else that's going to be used year round. The priority date of the water for fit for purposes, I think this one was 2014. And then it talks about the works which are authorized to divert the water. So well, pump, pipe, if it's a groundwater well, or if it's a surface water license out of a lake or something, you may have an intake, foreshore pump house, and a pump and that sort of thing. So, I mentioned as part of the transition piece, there was license application fees. The fee waiving for the transition period is over. So now any water license application that comes in has a license application fee for water use, a water license, a use approval, a change approval, or a drilling authorization. So those are the things that all catch fees from the province. Examples. Application fee for a medium-sized storage facility. If you're going to have a reservoir, divert water into a reservoir, the application fee is $500. Livestock and animal watering, $250. Private irrigation, below 250,000 cubic meters a year, $250. There's also a fee for an amendment. If you have an existing water license, if something comes up where you need to amend the license, say you've subdivided off the property and the appurtenancy is changing, there's an amendment fee, so you can correct that license, either split it in half between the two sublots or keep it and move it over onto the one lot. The application of the amendment fees are generally half of what the new license fees are. So $250 for livestock watering. An amendment to that license would be $125. And like I said, the fees are now applicable whether that source is surface water or groundwater. There's also annual rentals. The rentals, I will mention, the whole fees, rentals, everything is managed by the Water Revenue Branch out of Victoria under the Water Sustainability Fees, Rentals and Charges Tariff regulation. So the purse strings are held out of Victoria, of course. We don't do any of that sort of stuff locally. So whenever we get a call about it, we basically have to send them to our counterparts in Victoria. So the annual rentals for a water license are quantity based. There's a number of minimum thresholds, but those are defined by the purpose. So domestic use usually billed at $2.25 per 1,000 cubic meters, but the minimum threshold is $50. So anybody who has a domestic water use license out of a surface water source is paying the province $50 a year for the privilege of doing so. Just for clarification, 1,000 cubic meters. So there's 1,000 liters in a cubic meter, 1,000 cubic meters. So that's $2.25 for 1,000,000 liters of water is what that would break down at. So the second example there, water bottling, $2.25 per 1,000 cubic meters, or again, 1,000,000 liters. But the minimum per year is $200. Irrigation use billed at 85 cents a 1,000 cubic meters with a minimum of 50. And then placer mining billed at $1.30 per 1,000 cubic meters with a minimum of 200. So there's a number of licenses, a lot of licenses are below the thresholds. So the annual bills that they're getting are for those numbers, 50, 200, 50, 200, something like that. But there's a number of them that are, obviously larger and are over that, and then they're billed by the actual volume. I will say, this is a topic of great conversation amongst myself and my colleagues. This was a side conversation we were having at our most recent face-to-face in Richmond. Yeah, lots of opinions on this. And this is being recorded, so I'm going to leave it at that. When we get into assessing water license applications, we have these things called notations. So notations are attached to a source, and they're a water management tool used to indicate potential lack of water availability on a source, or if we know for a fact that there is no water availability. So they cover a range of circumstances. They mentioned that the water may not be available for licensing or for short-term use, or that the notations they originally started with surface water. Now they've moved into groundwater as well, because groundwater is obviously regulated now. So this introduces something called an idea called hydraulic connectivity, and it's something that we've been working wrapping our minds around now for several years. So if you think of an aquifer as maybe a big bathtub or something, it's full of sand. There's water in between the sand in those pore spaces. And if there's a stream flowing across the top of that, at some times of the year, water from the stream may be, draining down into the aquifer. At some times of year, depending on the pressure on the outsides, the water may be moving from the aquifer back into the stream. So if that's occurring, then that's the idea of hydraulic connectivity. So you can think if somebody has a well that's, I'll use the Smilkameen. If they have a well that's 50 feet off the edge of the Smilkameen and it's only 20 or 30 feet deep, that area is really gravelly, really sandy. So the water's, moving from the stream into the aquifer, from the aquifer into the stream. If they start drawing water out of that well, it's not going to take long before they're actually drawing water out of the stream. So they're drawing the water toward their well and drawing the water out of the stream. So if we have a notation on the stream that says no more water available for licensing, and there's a well, then we have to consider that well, as that water as coming out of the stream as well. So that'll influence what kind of a decision we're making on that. Does that make sense? Did I explain that? Okay. I'm sure there'll be questions. So there's a number of notations. Things like there's 5 different types. Application has been refused. So we've done the analysis. People have looked at water availability. Somebody's made an application and we've actually refused it. There's another one, possible water shortage, where maybe we've got some reports come in from neighbors or from past experience that says there may be water shortage in this area. There's more work to be done to determine whether there's actually water available or not. Fully recorded means that we've made sort of all the decisions we are intending to make on a source. So there is no more water available. Fully recorded with exceptions. So there may be a notation that says this is fully recorded, but we will entertain domestic water applications on this source, because domestic water is a relatively small amount and it can be taken sort of slowly over a time instead of a large slug of water all at once kind of thing. So there's some exceptions to fully recorded, or somebody may come with an application that says, look, I know this is fully recorded. I'm going to take water out of the stream when it's plentiful, say March, April, May, something like that. I'm going to put it into a reservoir, hold it, and then use that for the June, July, August period when, that stream is experiencing scarcity. And then we have something called an office reserve. So an office reserve is just a notation to remind ourselves that something is going on in that source. Maybe there's another project that's going on where we want to reserve making more decisions on that source while a negotiation is going on, while maybe there's some treaty negotiations or something happening. We don't want to make a bunch of decisions in the interim that are going to undermine that. So an office reserve just helps us do that. So some of the search suggestions, I didn't want to just include a bunch of links into a PowerPoint presentation because they're not really of much value. Sorry, Patrick. I know you did that, but so there's some water search suggestions that I would suggest. The first thing is Front Counter BC. So this is the online portal that receives water license applications. They receive all the applications for the work Patrick does. They receive mining applications, fishing license applications, hunting applications. So they're the full suite of provincial applications. So they've got people that are trained and experienced in answering water license questions, asking the applications. If anybody has any questions, first point is to head to Front Counter BC, either through their 1877 number, through their email, or just do a search for Front Counter BC. They've got lots of information on there. They've also got lots of links to the tools that Patrick was talking about, such as that discovery tool. IMAP BC is a tool that we use for my work quite regularly. It's another tool where you can bring in all the different layers to show the notations, to show property boundaries, to show whether a property has a license or not, license points of diversion, so you can see where that water is coming from to make its way to a property. There's another thing called the BC Water Resources Atlas, which is another mapping tool that shows pretty much everything water, pretty much everything related to a piece of property, and you can turn on and turn off layers as you need. There's another tool that there's a consortium of groups put together called the BC Agriculture Water Calculator. It's a really great tool that we use quite a bit, and we encourage clients to use it and applicants to use it as well, where you can zoom in on a piece of property, you can click on it, and then it brings up the soil types. It'll ask you what kind of a crop you would like to grow. It'll tell you what the most sort of expected season is for that crop. It'll give you the area, and then it'll calculate out what a rough expectation is the amount of water that you'll need to grow that crop for that season on that piece of property. It's a really good tool. It's a really valuable tool. It also has access to the database of existing wells, of water licenses. So it'll populate those up on the screen as well. So when you're looking at it, this makes no sense that I'm describing it to you without actually showing it to you. But unless we had a live sort of internet connected laptop that I could just do the work on, we can't really do that. So the other piece is that BC Water License Search tool that I mentioned. If you've got a file number, if you've got the person's name, if you've got the parcel ID as well, that's another one of the search criteria. So with that, that clock is a lot less intimidating now. All of a sudden, I've gotten through with a bunch more. So I think with that, we'll just open it up. I'm sure there's some questions. If anybody's thought of any real tough questions for Patrick, please stand up and ask them. No,
Thanks, Ray.
thank you.
I've got one online. We can go back and forth, I guess. What does the government do for enforcement if a well for domestic use is not registered?
Well, for domestic use is not registered. We're not doing any enforcement on that right now. If a well is not licensed for non-domestic use, then that landowner and that well owner is not authorized to use that water. So again, there's the two different streams. Yeah, another pun, I know. But there's the two different pieces there. There's a licensing piece or the registration piece. So if they're asking about registration, we're not enforcing that because that's a benefit to them. And if they're choosing not to do so, then there's no action on our part. If they are an unauthorized user from a licensing perspective, then we have a compliance and enforcement branch. We have folks in our office who will head out and start off with a gentle reminder and then sort of go from there.
You talked earlier about somebody applying for, I think it was a commercial license next to somebody that, let's say, had a quarter acre and they would be consulted about this potential license application.
Yes.
So in that license application by the applicant, they're supposed to disclose how much usage they would potentially be.
Yep.
How much water they would need. So if that went, let's say, exceeded it, and the guy next door, could that diminish how much water he's got for his own use?
Well, yeah, that's what we want to avoid, right? That's the discussion we want to have.
How do you monitor that?
How do we what?
How do you monitor how much?
One of the things you could do is if the new well is already in, if it happens to be in the ground already, you could run a pump test in that new well. So they would take water out of that well at the rate that is going to be expected for sort of the greenhouse or the commercial operation or whatever it is. Then we could monitor the level of the water in the homeowner well next door if the homeowner agrees to this. And if you ran the new well for 72 hours or something like that, and if you were running it at that high rate of withdrawal, and then if you saw a response in the level of the water in the homeowner's well, then you would know that this new use is going to be impacting this use. And we would have to do something to try and mitigate that. If you ran that well at a high rate and you didn't see any response in the other well, in the monitoring well that the homeowner's well would become, then you can infer that there may not be any impact.
But all I'm saying is the person that's made the applicant, maybe they don't always disclose what they want to disclose. And if you and it impacts the property next door, I don't know, I just see that as a potential source of serious contention.
Yeah, it could be. When somebody's making an application, a fundamental piece of the application is how much water are you looking for and how much are you going to be taking out at any given time? And we can't move forward with a water license application if we don't have that information. So if somebody's trying to hide that or sort of keep that under the table, there's no way they can.
Okay, thank you.
Thanks, Ray. We've got a few more online. Does an owner who applies for well registration need to be a Canadian permanent resident or citizen?
As long as they're the property owner, they're okay.
Thank you. Are the wells metered? I apologize if you already answered that.
Sorry,
Are
pardon me?
the wells metered?
Are the wells metered? That's for the most part, no. Another topic of conversation from our face-to-face we just recently had. So where I'm working in the Okanagan, we made a local decision 5 or 6 years ago that when we were issuing water licenses, we would be including a measuring and reporting clause on those licenses. Because as a sort of group of colleagues, we all got together and said, well, fundamentally, we kind of operate by the you can't manage what you don't measure sort of doctrine, right? So if we're we've had a very long period where people have water licenses and we're taking their word for it, how much water they're using. And we're sort of moving beyond that. So Thompson, Okanagan area, we're putting we're putting meters on water licenses as a clause. So when a new license goes in, when somebody has a well or a stream license, they're installing meters. They have to install a meter in that, and they got to hold that data sort of for when we want to use it. We're not collecting it yet, but they're metering, they're collecting their data, and then at some point we'll be asking for it. And if they haven't done that, then they're in non-compliance with the terms and conditions of their license, which is not a good spot to be in.
Thanks, Ray. I think, do we have a question on the floor?
Yeah, thank you. Not that I've had the experience of representing a lot of farmers, either buying or selling property, but a lot of the farms around my area have specific pumping stations that are in the city ditch. I imagine that they need to have a water license, and if the city decides to enclose the ditch, what's the circumstance around that situation?
Yeah, that's precarious, I would say, for them. We've run into this in a few areas, Okanagan specifically, and I'm sorry, but I'm using Okanagan examples because that's what I'm familiar with, where you've got maybe an old stream that has been ditched to try and make it run straight through somebody's property so they can maximize the use of the property. It's kind of a stream, kind of a ditch. It's not really one or the other. And in the past, we've licensed those locations. So yeah, people have the right to withdraw water from that location. If the water's not there, the license gives them the right to withdraw the water when it is there, if it is there, but it's not a guarantee that it will be there.
But to clarify, they need a license for the ditch, period.
So to borrow Patrick's phrase, it depends. Overland flow and water that is ditched for drainage purposes is not subject to licensing. So if somebody wants to drain a piece of property for agricultural purposes, they dig a ditch, water goes into that ditch and then flows down. That is not subject to authorization. If it was a stream, or if it was a stream at some point, then they would need a license because it still would be a stream. It's just that it's been altered to make it run straighter, or, moved over to the edge of a property rather than running through the middle of it. I'm kind of bobbing and weaving a bit on that one.
Be careful with farmers then.
Yeah, it's precarious to be in that sort of spot. But I am familiar. We know that has occurred and that is occurring in spots. Yeah.
Thank you.
Thanks, Ray. I've got one more question online and then we'll take one more from the floor. What happens if a new homeowner does not pay their groundwater licensing fee? Does the license then lapse? Would a subsequent owner reapply?
Yeah. I mentioned the Water Revenue Branch in Victoria. So we have in the Water Sustainability Act, there are rules about what we can do to suspend or cancel a license. And they have a sort of a specific subsection of that. So if somebody has a license, whether it's groundwater or surface water, if they don't pay their bill for 2 years, then they're subject to cancellation. And then it's a Water Revenue Branch in Victoria that manages that. They reach out to us sort of as the local, closer boots on the ground type folks to help them out with that process. Where we have generally the rules are if someone's not using their water license for 3 years, or if they're sort of unresponsive for us for 3 years, then we can move ahead with the cancellation process. Through Water Revenue Branch, it's only 2 years. So if someone has got 2 years of outstanding bills, or they haven't paid it for 2, they can expect in that 3rd year that they're going to get their invoice and an additional letter in the mail saying, pay up, or something bad might happen with that license. If that license is canceled, then yeah, and if the property changes hands, a new owner would have to reapply for a new license.
Okay, just a question about commercial use of water, the bottling plant, only $200 for 1 million liters of water.
Yes.
Is it too cheap?
Yes, as a citizen of the province, I would say absolutely. It's ridiculous. So taking off my public servant hat, and putting on my citizen hat, yeah, I think it's outrageous. Putting on my provincial government employee hat again, there's a process for changing the fees. It is subject to the whims and the interests of the current government of the day. It's a legislative, it's a regulatory change. I can say as colleagues, whenever we get a chance, we are advocating for changes to the whole fees and rental structure. We think there's room for improvement in areas where we can, we're talking about a provincial resource, right? The water belongs to everybody. It belongs to all of us. It's a provincial resource. So why would we be sort of essentially giving it away? I should end there.
Thank you, Ray and Patrick, for your time on a Saturday morning. I think you both have some gardening to get back to, so. Thanks again for your time. Quick couple of items. So the code, we have a sparkle theme with our gala. So your passcode for this session is bling. If you need assistance with where to enter it on the app, you open your event to Mobi app, click on the agenda on the 3 lines, click on seminar 1. Stop, wait, slow down. Once you click into CE seminar 1, scroll to the bottom and select session feedback. And there will be 2 questions. One is to enter the passcode, and if you want to provide feedback on the session. As long as you get it in, it doesn't have to be right now. You can come see myself or Nicola and Olivia at the registration desk. We will have a quick, if you want to quickly grab a coffee or a bathroom break, there is coffee outside. We will start promptly again at 11 a.m. So please be back in the room for 11 a.m. 5 minutes. We're down to 5 minutes. Thanks.